Okay, in this video I'm going to take a look at constructive dismissal and 10 things that you should know about constructive dismissal in Irish law. Firstly, number one, what is constructive dismissal? It's where the employee leaves the job. In other words, the employee terminates the contract of employment due to the conduct of the employer. It doesn't matter whether the employee gives notice or not, and it's one of the most common claims by employees against employers. However, it is a difficult claim to win. The burden of proof is a big factor in the constructive dismissal claim. The constructive dismissal claim means that the burden of proof is on the employee. So the employee has the probative burden and must prove that he or she had no choice but to leave the employment due to the conduct of the employer, and that it was a reasonable thing to do. Unlike in an unfair dismissal case where the employer must prove that the dismissal was fair. Just to be clear on that, if the employer dismisses an employee, the burden of proof is with the employer and he must prove that it was a fair dismissal. However, if the employee leaves, he must prove that he had no choice but to leave, so he has the burden of proof. The third thing is we look at some examples of constructive dismissal. These situations may give rise to a successful claim. However, they are not a definitive list or a determinative list or anything of that nature, but they do give some indication. A unilateral reduction in pay, for example, if your pay was cut by 50% or 30% or 25%, you probably would have a decent case for unfair or for constructive dismissal. However, if your pay was only reduced by say 2 or 3% and there was some rational basis for that, in other words to save jobs or something, then you may not have. So it will depend on the circumstances. A unilateral change in job function, a change in work location without agreement, a bad or toxic work environment. These have all led to successful constructive dismissal claims, but each case will stand or fall on its own particular circumstances. You need to be aware of that. Other cases which gave rise to successful claims: change in work hours without agreement, the conduct of fellow employees. If you're a victim of, for example, sexual harassment or any harassment, and the employer doesn't do anything, you could be justified in leaving the job and bringing a claim. And undeserved disciplinary warnings may also give rise. As I said already, this list is not exhaustive, it's not definitive, and your case will succeed or fall on its own particular facts and circumstances. In relation to remedies, compensation is possible of up to 2 years' salary. However, it's extremely unlikely. I have to warn you of that. It's financial loss that is possible by way of an award, and that's as per the Unfair Dismissals Act of 1977. You must mitigate your loss. That means you must try and get a job. You can't just sit on your behind and not bother getting a job or trying to mitigate your loss and letting the losses rack up. You can't do that. You're supposed to be trying to get a job. Other remedies for an unfair dismissal or constructive dismissal would also be reinstatement or re-engagement. However, reinstatement or re-engagement would be less likely in a constructive dismissal situation because, by definition, you've left the job yourself due to the conduct of the employer. Why would you want to be reinstated or re-engaged? Having said that, it is possible that whatever the issue was may have been remedied and things may be changed significantly, and you may be happy to go back and be re-engaged or reinstated in your job. Just in relation to financial loss, your financial loss is your loss of earnings between leaving the job and getting a new one. So this could be a very short period of time, it could be a long period of time. If it's only a short period of time, for example a week or 2 weeks or 3 weeks, then the maximum that's possible which can be awarded to you is 1 month's salary. So that's sort of a nominal recognition that you've won your claim, but you can only get a month's salary. Therefore, you need to consider whether it's going to be worth your while bringing the claim or not, because you will have legal costs, obviously. However, if you're out of the job for 3 months or 6 months or 12 months, well, then your financial loss is going to be 3 months or 6 months or 12 months, in which case it's a much significant amount of money, and clearly it may well be worth your while bringing the claim. Number 5, the requirements for a claim. You need at least 12 months continuous service in the employment. You must bring your claim within 6 months of quitting the job. This can be extended to 12 months if you can show reasonable cause. Reasonable cause is basically down to the reason as to why you didn't bring it within 6 months, and that's a matter for the adjudicator as to whether to accept your reasonable cause or not. I would very strongly recommend You must exhaust all internal procedures first, including, I would suggest, the appeals procedure. After that, then you may be able to bring a claim for constructive dismissal, but without going through internal procedures, you may be premature bringing your claim. You need to bring your claim to the Workplace Relations Commission, that's the WRC. You fill out the online WRC form and you tick the unfair dismissal options box, and you set out exactly when you started, when you finished, and why you had to leave. The tests for a successful claim, broadly there's two tests that have been applied by the Employment Appeals Tribunal and now by the Labour Court and by the Workplace Relations Commission. They will be the contract test and the conduct test. The contract test looks at whether there was a breach of the contract of employment by the employer, and the conduct test looks at the conduct of both parties. In other words, how reasonable or unreasonable was the conduct of both employer and employee. These are the two tests that you need to look at your case through and see whether your case, your claim, stands up or not. As I say, generally these tests have been used in deciding constructive dismissal claims. Number 8, a word of warning: it's a difficult case to win because the employee has the burden of proof, not the employer. The employee has it. You must prove that the conduct was so bad you had no choice but to leave. It's much easier for the employee if the employer has dismissed, as the employer then has the burden of proof and must prove that the dismissal was fair and that he or she had substantial grounds for dismissing you. Number 9, I would recommend that you get professional advice before quitting. And I mean before quitting, because you do not want to discover you have no case after you've quit your job. Number 10, the legal definition of unfair or of constructive dismissal is set out in the Unfair Dismissals Act 1977. You'll see there from the screen that it actually makes reference to the conduct of the employer, and it also makes reference to whether it would have been reasonable for the employee to terminate the contract. So that's the reasonableness test and the conduct test, and then there's the breach of contract test as well. Hope you find this video useful. If you do, give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. My contact details are there on the screen.